Hey, welcome everybody. Welcome to today's episode of Law Self-Defense. 2 minutes late. I'm sorry about that. I was about to go live and I realized I could work today and I had not brushed my hair once I got to the office and took the helmet off. Yes, I wear a helmet when I ride a motorcycle. It's not required here in Colorado, but it is required for my own common sense. So come on in, folks, make yourselves comfortable. And we have a platinum Q&A show for all of you today. We're going to go through a number of questions sent in to us by our platinum members, our Law Self-Defense platinum members. Platinum members have a dedicated Q&A form exclusively for them, where they can send questions to me directly. If they'd like them answered confidentially, they can indicate that on the form, and I'm happy to do that. Otherwise, we aggregate them and we answer them in these shows. And of course, we also email the member who submitted the question, so they, with the timestamp of when we answered it, so they can go see the answer for themselves directly. So those of you who are not platinum members, you don't get to submit questions that way. You do get to hear the answers of those we select. And I will make an effort today to answer questions submitted during the live show. So definitely any level of Law Self-Defense membership who's watching this in the member chat, I'll go through that and answer your questions there. And if you want to, if you're watching on YouTube and you'd like to do a super chat to ask a question, I'll consider those questions as well. It needs to be a $10 minimum super chat, folks, which is another way of saying you're crazy to do it that way, because it's less than $10 to be a Law Self-Defense member, and you can ask all the questions you want for no additional cost. But if you insist on not being a Law Self-Defense member, but have a question on YouTube you'd like to have answered, $10 super chat is the minimum, folks. It's always hard to guess ahead of time how many questions we'll get through, because it's hard to know how long I'm going to address each one. But to give you a sense of what I'm hoping to be able to cover, the questions that are queued up for today's show. The first is my state a stand your ground or duty to retreat state? The second is, looters will be shot signs. Are those lawful? Third is neighborhood security teams. If you put together some kind of voluntary neighborhood security team, say in the aftermath of some natural disaster, and one of them does something bad, is everyone on the team guilty? The Tueller Drill. Is a Tueller Drill time 1.5 seconds, like most of us have been taught? Is it 1.7 seconds? Is it some longer period of time? I'll address that. Is a law self-defense consult covered by attorney-client privilege, so that what you say to me in the course of the consult, our legal consult, should you be facing legal jeopardy in the aftermath of a use of force event, is what you tell me protected by privilege? Or could I be compelled to take the witness stand and share with a prosecutor, with a jury, with a court, what you told me? I'll address that if we have time. All of these are time permitting. And defensive display of a firearm. So displaying your gun to try to get someone to stop doing what they're doing that's scaring you, is that prudent or is that a felony? So those are the questions queued up for today. With that out of the way, let's go ahead and start with the formal launch of today's show. Oh, by the way, I should also mention, as is usual with these Platinum Q&A shows, the first half of the show is being live streamed on multiple platforms. It's being live streamed on our Law Self-Defense YouTube channel, our Law of Self-Defense Rumble channel. It's the Law Self-Defense Twitter channel, if that's what you call that. And of course, it's being live streamed to our members in the member chat. But the social media broadcast end about halfway through the show. So at about the half-hour mark. I'm setting my timer right now to remind me when that happens. And at that half-hour mark, if you're a Law Self-Defense member, don't go anywhere. We're going to do another half hour of Q&A coverage. But those of you watching on social media, your show will end at about the 30-minute mark. So just be aware. If you don't want that to happen, well, I would encourage you to be a Law Self-Defense member, so you get to enjoy all of our members-only content. I'll explain how to do that in just a moment. Here we go. All right. So for those of you who'd like to stay for the entirety of today's show, I would encourage you to be a Law of Self-Defense member if you're not. The good news is you can try out 2 weeks of Law of Self-Defense membership for 99 cents, folks, and you have all the access of any other Law of Self-Defense standard member, thousands of our videos, podcasts, blog posts, and of course, the new content we create multiple times a week, including our members-only content. And you can try that out for 2 weeks for 99 cents, folks, at lawofselfdefense.com/trial. At the end of that 99 cents, if you stay a member, it's still dirt cheap. It's only about 30 cents a day, less than $10 a month to be a Law of Self-Defense standard member. And if you'd like to be able to do things like take advantage of our Platinum member Q&A forum, those are the questions we're addressing today, and get the benefit of being eligible for a legal consult from Law of Self-Defense should you be involved in a use of force event. And we have extremely high rates of success, folks. It's virtually 100% success in either getting charges dismissed or deferred or getting acquittals at trial when we consult on a use of force case. But we only provide those legal consults to our Platinum members. If you're not a Platinum member, we're not available to consult on your case at any cost. So we do have a very special offer we're currently running where you can get 5 years of that Platinum protection coverage, my legal consult, at no cost to you, folks. By the way, when we took outside consults, it was a minimum of $10,000. But as a Platinum member, you get the consult for free. Plus, we have a bundle of $3,000 of our educational content, including this giant stack of video courses, online streamed courses, multiple copies of our best-selling book, The Law of Self-Defense Principles. We're going to give you for free, as a free bonus, as part of this offer, 5 years of Platinum coverage, $3,000 of our educational content for only 82 cents a day, folks. 82 cents a day. You probably have that on the floorboards of your car. Learn more about this opportunity at lawofselfdefense.com/82 cents. All right, so let me find where I put my questions for today. Here we are. Let's start with the first one sent in by Law of Self-Defense Platinum member David. So let me make a note of the timestamp here. This is David says, I'm finding contradictory information from what appears to be reliable sources about whether Arkansas is a stand your ground state or not. Which is it? Is Arkansas a stand your ground state? Well, the answer is that Arkansas is indeed a stand your ground state, but only very recently. And that this, when we have these kinds of statutory changes, we do run into these issues where the legacy legal status remains on the books, and apparently still the case. It takes time for the wheels of justice to catch up with legislative changes. Now, just generally speaking, if you are a Law of Self-Defense member, one of the things we do for our members is we do aggregate various facets of use of force law. Like here is the page that we maintain on which states are duty to retreat states. There's two options, really. Your state could be a stand your ground state, meaning you do not have a legal duty to retreat before you can use deadly force in self-defense in an otherwise lawful case of self-defense. And then there are the duty to retreat states, where you do have a legal duty to retreat, if safely possible, before you can use deadly force in self-defense. Now, stand your ground is not some weird parallel way of arguing self-defense. You're making the same traditional self-defense argument, the self-defense argument that's defined by the 5 elements of self-defense: innocence, imminence, proportionality, avoidance, and reasonableness. Up to 5 elements. That's the most elements you need to worry about in any U.S. state for a self-defense case. And one of them is this element of avoidance. And avoidance is the element where a duty to retreat state says you have a legal duty to retreat if safely possible before you can use deadly force in self-defense. There's only 11 states that are duty to retreat states. The other 39 states are stand your ground states, meaning you don't have that legal duty. They effectively, those 39 stand your ground states, take that element of avoidance off the table. in an otherwise lawful case of self-defense. But the other elements are still required. Innocence, imminence, proportionality, and reasonableness are still remain. So you don't have 5 elements to worry about in a stand your ground state. You have 4, but you still have the 4. All they're saying, all the stand your ground states are saying that if you have those 4, if you are the innocent victim of an imminent, unlawful, deadly force attack, and you otherwise conduct yourself reasonably, they're not going to put you in prison for the rest of your life because the prosecutor's arguing, well, you know, he could have safely retreated in theory with perfect hindsight from a position of safety, like we're evaluating it. They're not going to do that. They're not requiring avoidance in otherwise lawful case of self-defense. The duty to retreat states are saying they reserve the privilege to put you in a cage for the rest of your life, even if you are the innocent victim of an imminent, unlawful, deadly force attack and you act reasonably. They still will put you in a cage for the rest of your life if they believe you had a safe avenue of retreat that you didn't take advantage of. Now, were they there when you were attacked? Do they know with absolute certainty that you had a safe avenue of retreat? How could they? No, they weren't there. They weren't under attack. They weren't perceiving what you were perceiving. So I think stand your ground is the proper public policy. We should not be requiring the element of avoidance anywhere, but there are 11 states that still do. Now, the number of states that are duty to retreat states has been falling for decades, many decades. It's never gone up. So in my entire legal career, 30 plus years, many states have shifted from duty to retreat to stand your ground, but no state has gone the other way. And one of the states that made that shift, and on this, you would know this on this page. By the way, you can find this page for, you need to be a Law of Self-Defense member, but you can find this page at lawofselfdefense.com/retreat. We update it as the laws change. And as you see here, the 11 duty to retreat states, Arkansas was one of them until July 30th, 2021. So just over 2 years ago. Arkansas was, I believe, the most recent state to shift from duty to retreat to stand your ground. So to answer the question directly, is Arkansas a duty to retreat state or stand your ground? Well, effective July 30th, 2021, they are stand your ground. But prior to that, they were duty to retreat, which means everything written about Arkansas use of force law prior to this change in the law will say Arkansas was a duty to retreat state because they were. So if there are training materials that have been printed before the change in the law, they're going to say Arkansas is duty to retreat. If there are court decisions that were decided based on events that occurred prior to the change in the law, which is virtually all Arkansas court decisions on this question, they're going to say there's a legal duty to retreat. Because remember, from first the law has to take effect. The shift in the law from duty to retreat to stand your ground. Great. Now you're a stand your ground state, Arkansas. Congratulations. Smart move. But for the case law, for the court records, for the application of this new standard, this stand your ground standard to be present, to be applied to real people in real use of force cases, what has to happen? Sometime after the effective date of the change, the legal change, someone has to get into a fight. And the question of avoidance has to be legally relevant to the facts of that fight. And the person has to be prosecuted. And the person has to be convicted. Because if they're not convicted, there's no appeal. If there's no appeal, there's no case law created. Case law is the appellate court decisions. So they have to get convicted. And then once they're convicted, they have to appeal their conviction. And then it can take years for the appellate courts to actually hear the argument on their appeal. And then more weeks or months for the appellate courts to return a decision on that question. So what that means is it's very common to have a delay of years between this kind of change in the law from duty to retreat to stand your ground and having that change actually be reflected in the appellate court decisions, in the case law for the state. And until that happens, every court decision you're looking at says, oh, Arkansas, duty to retreat, duty to retreat, duty to retreat. So there's this time lag between the effective change in the law from a legislative perspective, a statutory perspective, to when that change begins to be reflected in the case law. So if you're looking at the question of whether Arkansas is duty to retreat or stand your ground, it's absolutely stand your ground, effective July 30th, 2021. But you won't see that reflected in the body of the law until some lagging time after that effective change. All right, the next question is from, I gotta remember to note the timestamp. Let's see. Is from Law of Self-Defense Platinum member Tom. Tom says, I've watched your rioting, looting, arson video. Let's see. That's a dedicated course we have, folks, that we produced. I might have a copy right here. I do. That's this course. This is the DVD version. Of course, we also have it as an instant access online streamed version as well. If you're interested in that lawful defense against riot, looting, and arson, you can find that where? Here. Defense against riot, looting, and arson at lawofselfdefense.com/RLA for rioting, looting, arson. Very well received course. And Tom asks, I've watched your rioting, looting, arson course. I have a couple questions. Could you discuss the legal aspects or ramifications surrounding what is frequently seen in the news following hurricanes and other natural disasters where residents put up large signs stating that looters will be shot? I suspect there's no difference in the laws in situations like this, but I would like to know if there are cases involving a situation such as this where emergency services are scarce or not available at all, as well as times when the state or local governments enact emergency powers, martial law. I can't really address the emergency powers thing. States do crazy things sometimes under their claimed emergency powers. We've seen in some hurricane type cases, for example, they just start going through neighborhoods, taking guns from people. Which is ridiculous on its face, of course. But on the question of looters, so I did a quick Lexis search. Lexis is a professional legal database on looting law. It doesn't really tend to come up normally in self-defense scenarios that we normally deal with here at Law of Self-Defense because it takes some kind of natural disaster, right? Or BLM or Antifa, which are political disasters. And there's lots of law on looting. Looting is typically a felony, often a very serious felony, 15 years in many jurisdictions. But there's not a lot of law on shooting looters. Can you shoot someone for merely looting? And I know that there's a lot of people out there who would like to believe that they're privileged to do that. They want to have the legal privilege to shoot looters and have that be lawful. So desperately that I see them read things into the law that don't exist. And they'll tell me, Andrew, looting is can be stopped with deadly force. And I'm like, well, show me the law that says that. And they'll send me a statute, and the statute doesn't have the word looting in it. And I'll say, well, this statute doesn't say what you say it says. It doesn't say you can kill someone for looting, use deadly force to prevent looting. And they're like, well, no, but I mean, looting is like, you can use deadly force to prevent a burglary, and looting's a kind of burglary. Well, no. This is like a Venn diagram, right? These are overlapping circles. Some looting would be burglary. In other words, unlawfully entering a dwelling for the purpose of committing a crime inside, usually theft. That's a burglary. But of course, if there's been a natural disaster, structures are destroyed. Houses are ripped apart. Tornado comes through and everything's shredded. If some stranger from the community starts going through those shredded homes and taking stuff, that's looting. But you can't really call it burglary. There's no structure to enter anymore. So not all looting is burglary. Obviously, not all burglary is looting. Looting is usually specific to being in the aftermath of some kind of natural disaster. So there is no explicit license to use deadly force to stop looting. Does that mean you can't put up a sign that says looters will be shot? I guess you can put up the sign. I mean, I don't know what law you're breaking by putting up the sign, by spray painting on your garage door, looters will be shot. I mean, maybe you'll deter the looters, but that's a different question than whether you can actually shoot the looters. Now, if you're a looter, you ought to be pretty concerned, because if people are painting that on their homes, they may not know they don't have legal license to shoot looters. They may just shoot you. Doesn't help you that afterwards it turns out that wasn't a lawful use of deadly force. And let's face it, if it's a real natural disaster, I mean, how hard would it be to, I mean, how confident are you as a looter that your body's going to be recovered by the authorities after the fact, so that there would even be an investigation? I'm not telling anybody what to do, looters or those who want to stop looters. I'm just making an observation about the natural circumstances that tend to revolve around genuine natural disasters. So I wouldn't be too concerned about putting those kinds of signs up, but just because you put the sign up doesn't mean you would have the legal privilege to shoot simply because someone was looting. Now, if the dwelling is still whole and they're apparently committing our burglary, you may have a legal privilege to use deadly force in defense of burglary. Certainly of your own home, you would everywhere if you're in your home. But if you're just like walking through your destroyed neighborhood with a rifle around, on a sling, and you're seeing someone entering some home, you don't even know the person's home, then it gets a lot more sketchy. So there's not a threat to human life there, presumably. I mean, if there is a threat to human life, then it's a straight up self-defense, defense of others scenario. One thing that can come up, where we generally talk about the element of imminence. By the way, if you want this 5 elements of self-defense law cheat sheet, you can get it for free. We make it available for free. It provides a brief definition of the 5 elements of self-defense. You can get it at lawofselfdefense.com/elements. It's just a PDF download. If you don't understand those 5 elements, you can't possibly understand use of force law. So I would encourage you, if you do nothing else, to get that. There can be circumstances. Well, let me step back. We usually talk about imminence. The element of imminence is meaning that the threat you're defending yourself against is actually occurring. You're getting beaten or shot at or whatever, or it's immediately about to occur. The aggressor's fist is drawn back, or they're reaching for the gun in their waistband, that kind of thing. A speculative future threat's not enough. But there is another definition of imminence that's broader than that, and that is where the harm to be avoided becomes otherwise unavoidable if you don't stop a particular act by an aggressor. And this could be like you're on a boat at sea, and someone wants to throw you off the boat into the ocean, and there is no prospect for recovery. You're going to drown if that happens. You won't drown instantly, but in an hour, 2 hours, 6 hours, whatever, you'll drown. So if you allow them to throw you off the boat, your death is otherwise unavoidable at that point. So normally, just shoving someone would not be a deadly force attack against which you could use deadly defensive force. But if they're shoving you off a boat, making your death otherwise unavoidable as a direct result of doing that, well, that becomes a deadly force attack at that point, even though it's just a shove. But it's a shove that will inevitably result in your death. The same can be true in these natural disaster scenarios. So you have bottles of water, maybe just enough for a reasonable expectation of when services will return to the community, and someone's trying to steal your bottles of water. That means you, your wife, your kids are going to die if that water is taken. In my mind, that's the same scenario. They are killing you inevitably. Your death is otherwise unavoidable if they take that water. That becomes a deadly force attack. If they're taking your wife's insulin, and there's no way for you to replace that insulin before she would die from the lack of the insulin. She's not going to die instantly. They're stealing the refrigerator, the cooler with the insulin in it, right? They don't know what's in the cooler, maybe even, but they know it's probably something good if it's in the cooler. Your wife will die if they get away with that cooler. Not instantly, but in hours or a day or 2 days. That becomes, in my mind, a deadly force attack because of the inevitable consequence of your wife's death if they commit what would otherwise be a simple taking of personal property, right? If there's no natural disaster and you don't have this dynamic and they're stealing your cooler, it's just stealing a cooler. It's just the theft of personal property against which deadly force would normally not be appropriate outside of a place like Texas. Let's see what else. Okay, so a variant of this question, also from Law Self-Defense Platinum member Tom. Let me note the timestamp. In your rioting, looting, arson video, you discuss a situation concerning a group being charged, criminally charged, due to the worst decision actions of any single member of the group, such as when neighborhoods may band together to barricade or isolate themselves from ongoing unrest. That was something I had not at all considered. Hypothetical situation, a neighborhood has barricaded itself and taking turns blocking, manning entrances to the neighborhood. I returned to my home at the end of my watch, only to find people found a way around the barricades and are actively looting my house. I am armed in my driveway when they come walking out of my house. What are my options? At this point, I'm not in my house, so it would seem to be simply defensive property, not highly defensible property. Or alternately, a hurricane hits our beach house. Once police open up roads and let residents back in to check on our property, I drive up and see a group of people looting the beach house. How should the situation be viewed? First of all, if you have a beach house, Tom, I have yet to get my invitation to the beach house. I'm a fan of beach houses. But second, I think you've got it pretty right here. So if you're inside the home, then it's a classic defensive, highly defensible property situation. If you're not inside the home, most of the special provisions for defensive, highly defensible property would arguably not apply. I mean, they might. It gets kind of sketchy. Are you in the curtilage? Are you effectively inside your home? Can you just go into your home? And now you are inside your home dealing with these intruders who have they unlawfully and forcibly entered? That's often a condition for defensive, highly defensible property. If the hurricane tore away your garage door, so they just walked in, did they break something to get in? The hurricane did the breaking. So, and of course, I'm not telling people what to do. I'm not telling you to not shoot or to shoot people who are looting your home. Just trying to explore here the legal dynamics, what kind of legal risks you could be exposed to. Because if a prosecutor decides that your use of deadly force was not warranted, you're looking at a murder or manslaughter charge and trial and prospective conviction. The possibility of life in prison without possibility of early release. So I'm always very hesitant to use deadly force in defense of property. If I'm in my home, my family's in my home, sure, classic defensive, highly defensible property scenario there. If I'm outside my home at some distance, and I know my family's not in the home, right? Because we're all in a separate, secured location because of the natural disaster. Am I willing to start killing people because they're stealing stuff out of my house? Let's presume it's stuff I don't need for survival. I wouldn't be super comfortable with that, no. If it was stuff I do need for survival, of course, you can use non-deadly force to stop the taking of your property. And if you threaten non-deadly force and the looters present as a personal threat, well, then it's a straight up self-defense situation. Then how much force you can use is a function of how much force they're threatening you with. Are they threatening you with imminent deadly force? And that could be weapons. That could be disparity of numbers. That could be disparity of size or strength. That could be some exceptional vulnerability that you have. If maybe you're an older guy like me, we don't bounce as easily as we used to when we were younger. Lots of factors that can come into play there. In terms of your original question, when people gather cooperatively in a use of force type of setting, so there's looting or there's rioting or there's a natural disaster, and you and a bunch of your neighbors decide, listen, we're going to arm up. We got body armor. We have ARs. We have pistols. We have IFAKs. Hopefully you're sufficiently equipped to do that. Hopefully your neighbors are too. It's very helpful if everyone's already got that stuff, because it's too late to get it when the natural disaster or the political disaster hits. Just fair warning. But we all have this stuff, so we're going to gear up. All right, that's the timer to end the public stream, but I'll finish this question here for everybody. You gear up, maybe you park some cars across the road to create a barricade, that kind of thing, to secure your neighborhood. Unfortunately, one of the people in your team is not of the best judgment, or they're an alcoholic, or they're mentally unstable, or whatever the case may be, and they shoot someone for no good reason. Certainly, say that makes them personally liable, criminally liable for that unjustified shooting. What about the rest of you? Could a prosecutor argue that, hey, you were working as a gang, essentially? You conspired to use deadly force in this unlawful way. He happened to be the guy who pulled the trigger. But if you or I were attacked by a gang of people using force unlawfully, it's not just the person who stabs us or shoots us who's liable for that unlawful use of force. It's the group. The group's acting cooperatively. So could a prosecutor charge all of you as accessories to that unlawful killing? And the answer is yes. They can make that argument. And then what would you say? Well, I had no idea this guy was such a lunatic. So why are you partnered with him if you didn't know? If you didn't know him well enough to trust him, isn't that on you? So again, I don't tell people what to do. So I'm not telling you not to work cooperatively with your neighbors. Frankly, I don't know what else I would do. But that is a legal risk that you're taking when you do that. All right, folks. So that was halfway through the show. So at this point, we end the public streams. No reason for you to miss the second half of the show, however, because you could simply become a Law Self-Defense member right now for just 99 cents. Open up another tab in your browser, lawofselfdefense.com/trial, 2-week trial membership, 99 cents. Sign up. You'll be emailed instructions for how to join us on the Law of Self-Defense member stream so you can continue our show with us. At the end of that 2 weeks, it's still cheap to be a member. It's only 30 cents a day, less than $10 a month to be a member, folks. And that's the minimum for one super chat question on YouTube. So I would encourage you to take advantage of that possibility. Before I go, I will take a look at the super chats from YouTube, because I had said at the start that if there's a $10 super chat question, I'll address it. And I should do that while everybody is still here. And there is one. How about that? Cycle Boy, $10 super chat. Thank you so much. Look at that. I forgot I had that button set up. Once you put your hand on the object, a cooler, a bike, contesting the theft, it moves from theft to robbery. How does that change the analysis? You have a legal right to hold onto your property. Well, it's not quite once you have your hand on the item. It's once they're threatening you with force to carry out the theft. So a theft involving a threat of force to a person makes it a robbery. And generally, robberies are forcible felonies. And a forcible felony can be defended against with deadly defensive force. Once there's any threat to persons, folks, it's not really a defensive property scenario anymore. Then it becomes a defensive persons scenario. And then the threshold for the use of deadly defensive force is, are you facing an imminent threat of unlawful deadly force harm? Or does your state have a provision that allows you to use deadly force to prevent a forcible felony, like a robbery? So that would be the question, but it becomes a self-defense question, not a defensive property question. There are crimes we may think of as robbery, like as property crimes, like robbery and burglary, but they really involve a explicit or implicit, explicit in the case of robbery, implicit in the case of burglary, threat to human life. And that's why those particular crimes typically also achieve the threshold of allowing for the use of deadly defensive force. But you don't literally have to be touching it. So someone grabs your cooler, they're stealing your cooler in a aftermath of a natural disaster. You've got an AR on a sling. You're not pointing at them, but you're resting your hands on it, as one does. And you say, hey, that's my cooler. Don't take it. And they reach for a gun in their waistband. Or they say, I'll shoot you if you try to stop me. Well, now they're committing a robbery, right? An aggravated robbery. A robbery involving a threat of death or serious bodily injury. That's just a deadly force threat to persons at that point. All right, Cycle Boy, thank you for that $10 super chat. Yeah, we haven't been doing the super chats, but I suspect not taking them at all is damaging us with the YouTube algorithm. So I think this is how we'll do it moving forward. We'll take super chats, but only if they're $10, which is the price you pay for a full-blown law self-defense membership where you could ask all your questions for free every month. It's only $10 a month, less than $10 a month, but there you go. That's how we do it. I'll do one quick refresh on this to make sure I haven't missed anybody else on YouTube, and I haven't. All right, YouTube, thank you for joining us for today's Law Self-Defense Platinum membership Q&A. It's been great. See you next time.